Welcome to the class Conveyancing and Legal Writings, Law 401, Section 1, Week 8, Part 1. Now, what is specified or special power of attorney? I already mentioned when, if the subject matter is not general, or when the subject matter is not general but restricted to something either specific or specially mentioned by the principal while drafting an instrument, then it is not constitute as general power of attorney. It will constitute as specific or special power of attorney. Therefore, principals can specify exactly what powers an attorney can exercise by signing a special power of attorney. This is for used when one principal or one party cannot handle because of health reasons. The dates must specify in the specific power of attorney. That means a special power of attorney is one by which a person is appointed by the principal to do some specified act or acts. In this type of power of attorney, an agent or an agent or the attorney or attorney in fact with conferred with a power to do some specific act in a single or specified transaction in the name of principal. For this purpose, please remember attorney sometimes called as attorney in fact, sometimes called in constituted attorney, sometimes it's called as agent, but all are attorney, and the uh, donor is considered as a principal. Next point is durable power of attorney. A power of attorney which specifically says otherwise agent's power ends if principal become mentally incapacitated. However, a power of attorney may say that it is to remain in effect in the event of future incapacity of the principal. A power of attorney that says it a power of attorney that says can consider as a durable power of attorney. That means, according to the essential of contract, a power of attorney becomes ineffective if its grantor or principal dies or incapacitated because he or she is not capable to enter into the contract, unable to grant such a power because of physical injury or mental illness or unsound mind or anything. But there is another provision that if the grantor or principal specifies that the power of attorney will continue to be effective even if the grantor or the principal becomes incapacitated. That means he already gave the permission by the terms of the power of attorney that even if he becomes incapacitated, the attorney or attorney in fact can do all the acts on behalf of him, or specified acts which is indicated in the power of attorney can act on behalf of the principal. These types of power of attorney is called power of attorney with durable provisions or durable power of attorney. Sometimes it is called endurable power of attorney or lasting or continuing power of attorney. In effect, under a durable power of attorney, the authority of the attorney in fact to act or make such decision on behalf of the principals or grantor continue until the grantor's death. That means this type of power of attorney uh, will continue even if the grantor on the principals becomes incapacitated. Not after his death, before principal's death, but not be considered as ineffective after his incapacity, or he will not be capable to do anything, physical injury or mental illness. Sometimes a durable power of attorney can also be a healthcare power of attorney. This particular affidavit gives the attorney in fact or constituted attorney the attorney authority to make healthcare decision for the grantor or the principal up to and including terminating care and life support. The grantor or the principal can typically modify or restrict the powers of the agent to make end of life decision. So for durable power of attorney, you have to remember that it will continue until the principal's death, and it will continue even if the principals become incapacity because of physical injury or mental illness. Requirement of power of attorney. To ascertain whether power of attorney is of general or special power of attorney in nature, the subject matter in respect of which power is conferred is to be seen accurately. That means which power is conferred is very important part. The power of attorney is a unilateral document because it is made between the principal and the attorney, wherein the donor or the principal gives authoritative power to the agent by signing the documents, and the agent's or the attorney's sign is also required. Therefore, terms and conditions of the power of attorney is very important and must be included all the essential elements of the contract, which I already discussed in our past videos. Thus, by making offer and acceptance of a power of attorney, the legal relations of principal and the attorney would be established between the parties. And most importantly, a power of attorney can be executed by any person who is competent to enter into a contract. Competent means major, sound mind, and not disqualified by law. A company, while executing power of attorney, must make conformity with the Article of Association and its common process. Therefore, a person must be competent to give power to the appointed person so that it will not affect the legality of the instrument deed of power of attorney. That means competency of the parties is very important part, and competency of the parties is one of the essential part of a contract. Most importantly, a power of attorney should only be given to a person whom you can believe and trust to act on your behalf diligently, is both responsible and loyal to principal or to you. It is very important. If you cannot trust him or believe him, please don't give any power. There are few informations which are very important for a power of attorney and need to take precaution regarding those issues. Number one, by inserting a date of expiry, the principal can make it be time bound. That means principal can insert a specific time for a power of attorney and can include if principal dies, the power of attorney automatically revoked. Number two, one can give power specifically instead of the wide range of matters. That means in specific matters only. So a principal can make either general power of attorney or can specific power of attorney. Specific power of attorney is better than general power of attorney because it is in specific power of attorney, principal can give power specifically, not in wide range. Number three, not to emphasize of the attorney with great care and discretion, especially in matters where doing so can have a big impact on your finance. Obviously, it is very important part, because if you give a power to emphasize that the attorney can do anything with his discretionary power, then there is a chance the fraud, he can make any types of fraud, especially in case of finance, or in relation with finance, or in relation with banking, or any financial matter, etc. Last one, number 4, include an indemnity clause as compensation in the agreement signed by the parties. If you want to pay anything to attorney, you can write down that, or any types of clauses regarding remuneration, you or the principal can include in your legal instrument as power of attorney. Finally, as because a power of attorney is a legal document that has to be properly framed, obviously, using the right legal terminology and setting out the objectives and responsibilities with different matters, which I already indicate you that there are two types of power of attorney. One is general, one is specific, and specific is better than the general power of attorney. And obviously that must be principal's wishes to authorize the attorney to carry out on his or her behalf. If a person wants to authorize someone to act as a power of attorney on his behalf, he must be signed and certified by an advocate who is able to declare that you are competent at the time of signing the document to issue the said power of attorney. So obviously, power of attorney is a legal document, and that has to be properly framed with or by that has to be properly framed by maintaining the formalities for power of attorney under Bangladesh Labor under Power of Attorney Act 2012 or Power of Attorney Rules 2015. Again, for power of attorney, time is the most important element. A general power of attorney remains in force unless expressly revoked or determined by the death of either of the party, because normally and generally no specific dates are mentioned in the general power of attorney. It is a wide range power of attorney. A special power of attorney will be in force until the specified act is not completed, or duration of power will depend upon the type of attorney, or there may be a fixed period of power granted by the principal, which must be included in the deed. So for special power of attorney, there can be two types. Number one, the specified act is not completed, so the specific power of attorney can depend on the specified act, or can depend on the time, but that must be included in the deed. Thank you. That's all for today. Hopefully, very soon we will meet by Google Classroom as consultation hour. If you have any questions, please feel free to ask me on Google Classroom as consultation hour.